This is passage number 4. Duration 6 minutes. Speed 100 words per minute. Dictation starts now. The present group of first appeals arises out of the common judgment and award passed by the learned reference court. The appellants are the original claimants whose lands were acquired by the state government for the construction of a medium irrigation project. The notification under Section 4 of the Land Acquisition Act was published in the year 2012. The land acquisition officer, after following the due process of law, passed an award and fixed the market value of the land at the rate of 2 lakh rupees per hectare. Being dissatisfied with this amount, the claimants sought a reference for enhancement. Para. The reference court, after recording the evidence, enhanced the compensation to 4 lakh rupees per hectare. However, the claimants are still aggrieved and have approached this court seeking a further increase. The learned counsel for the appellants contended that the acquired land is very fertile and has high commercial potential due to its proximity to the national highway. He submitted that the sale instances produced by the claimants of the adjacent village were completely ignored by the lower court. It is further argued that the court failed to grant adequate compensation for the fruit bearing trees and the well situated on the land. Para. The learned assistant government pleader appearing for the state strongly defended the award. He submitted that the sale deeds relied upon by the claimants are for very small pieces of land and cannot be made the basis for determining the value of large tracts of agricultural land. He further argued that the reference code has already doubled the compensation and there is no evidence on record to justify any further enhancement. The state contends that the land in question is dry crop land and does not have any irrigation facilities. Therefore, the present appeals are liable to be dismissed as being without any merit. Para. We have carefully considered the rival submissions and perused the oral and documentary evidence. The main question for determination is whether the compensation awarded by the reference court is just and reasonable. It is a well settled principle that while determining the market value of the land, the court must sit in the armchair of a willing purchaser. The court should take into account the location, the nature of the soil, and the potentiality of the land for future development. In the present case, the map shows that the acquired land is situated within 2 kilometers of the developed industrial zone of the city. Para. Furthermore, the claimants have produced a valuation report of an expert which shows that there were more than 50 mango trees on the field. The reference court has awarded a very meager amount for these trees without any scientific basis. In our opinion, the income capitalization method should have been adopted for valuing the fruit bearing trees. We also find that the deduction of 30% made by the lower court towards development charges is on the higher side. Looking at the overall circumstances, we are of the view that the claimants are entitled to receive 5,50,000 rupees per hectare. Para. In addition to the enhanced market value, the claimants shall be entitled to all the statutory benefits, including solatium at the rate of 30% and additional component as per the law. They shall also be entitled to interest on the enhanced amount from the date of taking possession till the date of actual payment. The state is directed to calculate the difference and deposit the same in this code within a period of 3 months. Accordingly, the appeals are partly allowed with proportionate costs. The registry is directed to draw the decree accordingly. The pending civil applications, if any, shall stand disposed of. Over. Stop.